morning, guys. You know, kind of lucky to be up here. I think as I look out, any of you guys can be up there open today. And I really enjoyed practicing with a lot of you. So I'm going to share some things that have really tried to make my life a little bit easier for myself, as well as hopefully my colleagues. So when I do an intake, when it comes to their age, kids, married, not married, income, things along those lines. The one thing that a lot of people, I shouldn't say a lot, that I've seen people neglect to find out is paternity been established? You can't go anywhere unless paternity is established. So if you want to look, if they've never been married and there's no custody order and they come in, you want to first find out, has there been an acknowledgement filed or has paternity been established in one way or the other, either through DSS or by the two people. You need that to go forward. And sometimes that just gets by people. But when you're doing the intake, you're kind of formulating as you're going on where this is going to go. You're going to get their income and make sure you get it all. If somebody's retired and they're not working, they may say they have no income, or they're on disability and they don't believe that they have any income. Common thing that you hear is, I don't pay taxes on it, I don't file income, so it's not income. Not true. You've got to make sure that how they are surviving, you want to make sure you know it. Also, if they roll up into your office in an S-Class Mercedes and they're claiming $15,000 worth of income, there's something there you want to explore. Because even though they may not get money in their hand, other types of income can be considered. A car allowance, food, lodging, things of this nature that can be counted in an overall setting. So when you're doing the intake, you want the basic stuff, their names, dates of birth, ages, have they been married, do they have prior support orders, not for the case that they're coming in with you on, but do they have other children that they're supporting? You want them to bring in everything that they have. Prior court orders, prior acknowledgments, prior divorce agreements, as well as what they're coming in for you on. Every time we file a petition now, petition processing wants a copy of that old order or the most recent order. So if you don't have it and you file the petition and you run, in about 5 days you're going to get a big packet back from the family court. It's going to have everything in it that you filed, and now you just wasted time. Because remember, the date of the filing is the trigger date for everything that you're talking about, unless there's a prior court order that you're trying to enforce. The other things that you want to know is who's living in the house. Even though the obligation may go to or from a particular person, there may be income of the house that you need to consider. So you want to know, is your client married? Is your client receiving support from another source? Child support, maintenance. You do need to get all these information for you. Your employment history, have them bring their taxes and everything else that they get. Because sooner or later, you're going to be filing your affidavit of financial status with the court. You want to have that done prior to your first court appearance so you can hand it up to the support magistrate and be ready. Most embarrassing thing is you get in there your first date and you're fumbling through. Judge Amon asks you a question like, how much does your client make? And you got to lean over and ask your client. That stuff you should know, and you should be able to hand it up, copy of the tax returns, and you're good to go. Make the judge's job easy. The other thing you want to know is who, if anybody, are they attending college? Are the kids working? What is the access schedule? So once you get all that information down and you know what you're doing, they're either going to be doing a modification petition, they're going to be doing a violation petition, they're going to try and terminate support, they want more support. And the one thing that I found out in almost 30 years, the people getting support aren't getting enough. And the person paying support is paying too much. So somewhere, the truth is going to lie. Never, ever give your clients unrealistic expectations. That is the worst thing that can happen. Not only to you, but to the whole case. If somebody has unrealistic expectations going into court, this whole thing, the tires are gonna pop off the whole car. Because now, they're not gonna wanna settle something because in their mind, they've got something that's unrealistic. You have to be able to sit there, ready to tell them, this is what I think it is. Be prepared to tell them. Don't try and just get hired because you wanna represent somebody. That is a big mistake too, because you may be setting yourself up for something that you can't get out of down the road. So if it's two W-2 wage earners and that's really what's going on, know the law, calculate it out, explain it to them before you go to court. And when things happen that you say to your client and it happens in court that way, your credibility just shot up with that client. So when you're bringing this in, if you're doing the violation petition, you want to know because there's different types. If you're bringing it over from Supreme Court, it's going to be enforcement. If it's a prior family court order and you're violating them, now. Is it a willful or not? Just because they haven't paid does not necessarily make it a willful violation. You must know the law and plead it in your petition. Don't jam everything into a modification petition because not everything is a modification petition. So when you're drafting these petitions, know what you're doing. Just like any other court case. And we're lucky Judge Amon has the ability to let people try their case, but he knows the law probably better than anybody in our district. So he appreciates it when you come prepared, you know the case law, you're pleading what you're pleading, and you know the burden. And you don't have to put him in a position to dismiss a portion of your petition or the whole thing because you pled it wrong. The different burdens for the different petitions, once you've made your determination as to which petition you're going to be filing, you need to know the law and the burden on each one. Where now we have the 3 exceptions in which you can seek a modification. The 15% up or down, the 3 years that have gone by, obviously a change in circumstances. So you need to know the date of the last order that you're going to be trying to modify. If it's prior to October 2010, those 2 prongs don't exist. So don't embarrass yourself by coming up to the support magistrate and saying, their income went up $50,000, I want an increase. Wasn't the law then. 2 things are gonna happen. Judge is gonna dismiss it and you're gonna be embarrassed in front of your client. So always check the date in which the last order is that you're going to be modifying. If it's the first time, you don't have anything to worry about. Just bring it the way it would be. Plead and prove it the way it should be. Try and, if you know the attorney that's going to be on the other side, try and reach out to them first to say, get a little bit of information on the other side. You can get a little bit of knowledge before or at the stage where you're going to be going. Do it. Try and see what you can do to work that into any type of possible settlement. Preparedness is probably the best advice I could give anybody. The more prepared you are, the better you look in the eyes of the court. And you do that starting with the petitions that you file. You do that with creating reasonable expectations within your client's mind. Never, ever, even if you're sure, guarantee an outcome. Sometimes they're wrong. So you want to make sure that you never guarantee anybody a particular result, regardless of how sure you are with the law. So in wrapping up the intake, there's some forms online that I've used in regard to what you should really look for, what you can ask for, depending upon what type of issue is being presented to you, what type of petition you're going to file. Know the law, no unrealistic expectations, get them in, and start to get a roadmap of your case.
Jim talked a little bit about this reputation issue. Develop your reputation and your positive reputation early on. Something you work on. Being prepared, being on time. If you're going to do something, do it. Attorneys come in all the time, and you get your reputation as to whether you are on time, you are prepared, you're constantly leaning to your client for answers. So try to be very diligent about your reputation. It's very easy to lose your reputation on a bad day. Same thing, come in prepared, as Jim said. Know the questions, anticipate the questions I'm going to ask. Even in the first appearance, use the yellow pad and mark down the ages, the incomes, the medical insurance information, the child care, and that's about 3 minutes worth of work for you. But anticipate, if you were doing my job, what you would ask. The Child Support Standards Act has been around since 1989. It preceded most of you in this room, not all of us. Before the Child Support Standards Act, child support was set based on needs and abilities. There were no formulas to do child support, and the orders were low and inconsistent. It was the federal government that changed this all around. They mandated the states to incorporate a mechanistic approach to child support, and that's what we have right now. The Child Support Standards Act is the same that we apply on Section 413 of the Family Court Act as Sue does in the Domestic Relations Law 240. It's the same act. The approach to child support under the Standards Act can be done in a couple of different ways. I'll say there's 5 different steps. As Jim indicated, you have to have paternity established, and you also have to have a custodial parent. Now, it might not be clear or a parent coming in, but we don't require an order for a custodial parent, but we have to have someone de facto has to be the custodian. So the first thing we do in setting child support is we find out what the income is, and the definition of income in the Act is very expansive. And I'm type is actual income, tax return income, W-2 income. I would include workman's compensation, disability, Social Security benefits, veterans benefits, pension, retirement, fellowships, money that someone actually receives. A couple of issues we get frequently where a payor will insist it's not income are the Native American annuities, for instance. They get those, many times it's insisted that we can't take support out of them, but we can use that to establish support. If you're representing a custodial parent, you take the position that everything is income. You probably are not going to go wrong. But we add to that another type of income, discretionary imputed income, which is some odds and ends that don't fit easily. Jim talked a little bit about, I think, perks and provision of medical insurance coverage or automobiles or things like that, fringe benefits. Money services provided by someone else. Maybe your girlfriend is paying all the bills for the non-custodial parent. The problem with those is normally quantification. You can tell us all you want that we should include it, and we would like to and we should, but unless there's a good way that we can quantify it, it's hard to do. So you got to let us know how you think it should factor into a computation. Mandatory imputed income is a third type of income. We do a lot of imputing income in this stage. Someone quit a job, someone won't take a job, is voluntarily underemployed or unemployed, someone got fired for a job. We're looking at the skills, the education, past income, why they're not working at that job, and if you represent a custodial parent and the non-custodial parent is not employed, I think it's your job to look at why that person is not employed and to try to make a case for imputing income. And the final type of income is non-recurring payments, gifts and inheritance, lottery winnings, litigation awards, statute says things of recovery of bad debts, things like that. And these too are quantification issues. Someone may get a litigation award of $1 million. How am I to treat that as income? And there's not a lot of good case law on that. You want to, first thing you do is look at what case law we have at that particular time. But there may be other rationale that you have for me to use that particular income. And those are not easy cases or hard cases, but that certainly is income. We establish the income. That is the first job. The second job that we have in the statute is to subtract the statutory deductions. What comes out of income before we apply the percentages. And the several things that we see all the time are child support paid on behalf of a non-subject child. So if a payor comes in and has another child support order, that will come out of the top of their income once we find it. Alimony or maintenance paid to either a party spouse or a non-party spouse comes out also. So those are basically the things that will come out. You may want to argue to me that other things should come out, but you have to either fit it in the statute. Once we get the income, we subtract the deductions, then we multiply by the percentages, which I think everyone knows, 17% for one child, 25 for two children, 29 for three, 31% for four children, and 35% for five or more children. And those children got to be situated in the same family. If there's one child here and one child there, a payer will often come in and say, well, I should just be paying 25%. No, you're going to pay 17 for the first one, and then when we adjudicate the second one, that 17 will come off, but you'll pay another 17%.
Clients have to realize that 3 children with 3 different women is 17% times 3. 3 children with 1 woman is 29%.
Once we do the math, we find the income, we take out the deductions, we do the math, then we prorate the number between the parties based on the parties' particular proration of incomes one to the other. So it sets up an obligation in paper anyways from custodial parent and non-custodial parent, and obviously the custodial parent doesn't pay. There's a number of reasons why we have to kind of prorate that. One is when you do the add-ons, the uninsured and the medical insurance premium, things like that, we have to prorate those add-ons. So we have to find the proration of the parties' incomes one to the other. Secondly, if you get over the cap, which we're not going to talk a lot about today, but if you get over the cap, which is right now $143,000, it's discretionary as to how we apply the income to the non-custodial parent, or the obligation to the non-custodial parent. When the legislators did the law back in 1989, they wanted to be certain and to be apparent that both parents have an obligation to support the child. It looked better in terms of the legislation. So that's the fourth thing we do, is we prorate the obligation between the parties. Obviously, if you're not dealing with a cap issue though, it's easy for you to advise your client by just taking the income less the deductions times the percentage. The proration is that exercise you don't need just to start talking on the matter with your client. The fifth issue is the add-ons. And the add-ons are as follows. First of all, medical insurance coverage. Every order we do is going to address medical insurance coverage in some way. So you got to come in with that information, whether it's available or not. If it's available for your client, you want to get this information early on. How much does it, even if it's not available or it's not being used, let's say, your client is employed, how much is it going to cost your client for single coverage, and how much is it going to cost your client for family coverage? That's important for a couple of reasons. Medical insurance coverage can be forced if the coverage is available, and availability is defined as 5% of gross income. So if your client's family portion is going to be more than 5% of the gross, technically it's not available, and then the party should be able to get Medicaid and Child Health Plus. Know what it costs for insurance for single and family. The other reason you need that is we can prorate and should prorate the family portion. We should deduct, we should find out, again, on a prorated basis, how to charge it to each side, and it will come off of the child support obligation what the custodial parent would owe. That would be subtracted from the child support obligation. If custodial parent is providing it, the non-custodial parent's portion would be added on to the obligation. Depending on your position, you should be creative and argue and advocate for your client. There's two theories. One is if you already have the insurance in effect, it's not costing you anymore to keep the insurance. So I can certainly understand that argument. There are some policies now that have single and one and single and two, so sometimes it is more. But certainly if you represent the custodial parent, your argument's there already. No change, no difference. But I do listen carefully to a proration argument too. That is, let's prorate that family coverage now between the child that it was already existing for and the new child. Many times I find when that's the case, there's already a case ongoing in the family with the judges in terms of custody. And in those cases, we will yield to whatever finally happens. There should be a designated residential parent coming out of the custody court, and then that parent can then ask for child support. As you know, the case law provides that if there's equal time 50-50, the non-custodial parent is the parent that earns the most of the income. That's the Pastor-Rossoff case. The other add-ons that we deal with, aside from the medical insurance coverage, the premium, of course, the uninsured health-related expenses. it's mandatory that we divide those pro rata between the parties. I always try to include a schematic that, well, you got every month you have to send the bills over the other side. Every month you send your 50% or whatever it is back. I think that's good practice, and when you're settling the case, to ask for something like that. Child care expenses necessary for employment or education are mandatory add-ons. Those generally are payable the same way. Submit the bill, pay your percentage back. We will, or the child support unit will not do those expenses unless it's a sum certain. Childcare changes from week to week, season to season, year to year, so we usually don't do a sum certain, so it depends on the custodial parent and non-custodial parent working those out. If there is non-compliance with childcare issues though, then we're gonna average them and we're gonna put the number through the child support unit. So if that becomes a problem, we will do that. Education, as we just said, is a discretionary issue. I mentioned the cap briefly, and that's at 143 every 2 years. It gets adjusted to the consumer price index. There's inversely conversely the self-support reserve, which protects payors at a certain level, and you do a $25 a month or $50 a month order, you get down to a certain level. I mentioned variance or deviation from the guidelines. That's the most important thing. We're just going to run right by it here. But in every dynamic, every court, every hearing we have, custodial parent wants that presumptively correct amount, and non-custodial parent wants to vary. So you have to know 413, the F factors, as to why you're going to vary from the percentage. Are you going to cause me why to award less support? It can be because of visitation access time that is very close to half or extraordinary, let's say. It can be because your client has other children to support in family or out of family, but there's no formal order. Those are the ones we see frequently.
Flow case has to start off with what type of petition did you file? What flow is it going to take? If it's going to be a violation petition, what didn't you get? What were you supposed to get? If you were the one being accused of violating it, any proof that you have, that you've made payment, make sure you get that. If in fact somebody comes to you in a violation case, they're not working, find out why they're not working. Is it medical? Is it an accident? Is it laid off? Are they unemployed? Find out the reasons. And if it's just because they're not working, get them out there to put in applications, because you're going to need that down the road. So you want to know what flow your case is going to take depending upon the petition that you're going to file. Now, after you've done your homework, you're meeting with them, and you figure out a support obligation, break the news to the person who's paying it, and you say, you have to pay X. Well, you know what? It's a lot of money, but I think I can handle it. And then you say, well, that's not it. You also have to pay a portion of the daycare. Okay, well, that's a lot of money. All right, I can pay that. That's not it. You got to pay a portion of the uninsured medicals as well. It's like now, after you've given them a number, that number now has 3 different things that have been added to it. Again, this goes back to the expectation. You don't want your client to hear for the first time in court that the number is completely different than what you've provided him or her. So get them ready for it. Make certain that when you are doing a case and you're looking for those add-ons, is there something that you can provide the court that's different? Can your client provide insurance that's cheaper? Can your client provide daycare? Can your client provide any type of add-on at a more reasonable price? And the sell is, you're saving money for both people, not just yourselves. But know which way you're going to go. Start thinking about where you're going to go with it. Like I said earlier, the people that pay always think that they're paying too much. People that get it think that they're not getting it. What I say to a lot of my clients are, it is much better if you and your ex and me and the other attorney can work up something that's reasonable. Either that you're both unhappy or you're both happy. And that seems to be a little bit more fair. My theory, the way that I look at these, and you have to have reasonable persons. One person can be the most reasonable in the world. If you don't have somebody reasonable on the other side, it's not going to happen. But if you can, knowing the law, knowing the guidelines, knowing the parameters, and providing them, for me, that's a win-win situation. Now, if it's not going to happen, You gotta know the flow. Where are you gonna need? What information are you going to need? And then you start the discovery procedures in which you're going to do. You all have an obligation that if you know something, you have to be, your first job is to be ethical. You can't put forth something on your name that you know not to be true. There is no case that any of us take at any point in time that is worth your ethics and your reputation. It's not worth any of our ethics to try and either hide, non-disclose, or anything that you know should be disclosed. After your first appearance, or towards your first appearance, you're kind of getting to know your client's personality and the flow of how they're going to be. You want to explain what they're going to expect at their first appearance. If you have somebody that is going to be talking all the time, very animated, you want to tell them, that's what I'm here for. I'm going to be doing the talking. I don't need you blurting things out. I don't need you flaring your arms or twisting your head when somebody says something. Sit there and let me represent you. That if in fact your client becomes animated and starts blurting things out, you need to control that right away. But you want to get them ready. And if they're ready for what's happening, the less blurting is going to happen in there because, all right, yeah, Jimmy told me that was going to happen. Or, okay, yeah, I got to hand that out. So get them prepared for the first time. At that time, support magistrate may say, okay, give me what's going on here. And if in fact it's 2 W-2s, they may give a recommendation. This is how I think it should go. Take it seriously because they may be forecasting what is going to happen. Now, each of them may say, I haven't made up my mind. I haven't heard all the information. I haven't seen all the evidence. But if everything is going to come in the way that you're saying that it's going to come in, give that some real serious consideration. Because these people, this is what they do for a living. And they may be telegraphing what's happening. Take that back to your client. Say, realistically, and hopefully, you've done your job and it's in line with what you think that it was going to go. You should know where your case is headed. There really shouldn't be too much of a surprise in regard to what's going on if you have all the information. And they should not be surprised when they hear any type of number that's provided for. Take it seriously, see what you can do about settling. At your first appearance, in regard to that, they know what's going to happen. Don't interrupt each other. That's just, it's hard for the tape, it's hard for the support magistrate, and it's unprofessional. As much as you want to say something, and as much as your client may be elbowing you in the side and whispering in there, don't. It is always much more professional to let somebody say whatever they need to say, and then the court will always give you the opportunity to say something back. First and foremost, remind your clients that the microphone is on, and even if they're whispering, it gets picked up by the tape. So if they say something and you don't hit the button to stop it, it's part of the record. If in fact it's a case that requires documentation, you want to get that as soon as possible. If it's something that needs to be subpoenaed, you want to do that as soon as possible. If there's witnesses that you need to do, you need to contact them as soon as possible as well. Know your opponent, know what they're like. Everybody's worked with everybody in here pretty much. Everybody that I've worked with in here has always been very professional about everything. Talk to them, see what you can do. Let them know, okay, this is how I see it. What do you see? See if your case is really going to go forward or not. Do your work, know the law. The flow of the case really depends upon the petition that's been filed. We've already talked about knowing the law. We've already talked about preparation, expectations, and client control. You'll know. At that point in time, you're going to know what the outcome of your case really should be, unless somebody has been untruthful with you. So the flow of the case really is kind of a roadmap up until where you're going to trial and possibly settlement.
We will always give everyone a chance to talk. I frequently start on the one side, the petitioner. If you're the petitioner, I'm going to say, what do you want? What does your client want? Or something of that nature. Or have you talked to the other side? But I'll start there, and you got to be patient on the other side. We'll get to you, and then you can and let your client know that's what's going to happen. Overview of the court's function. We'll step back a little bit. I'm a support magistrate. There's 5 of us in Erie County, myself, Mr. Bernholz, Ms. D, Ms. Marico, and Mr. Winsek. And our jurisdiction is paternity, child support and child support add-ons, and spousal support, just what we talked about, we've been talking about all morning. On spousal support, the maintenance, by the way, that's a brand new animal for us because we're now subject to the maintenance guidelines that they've been made permanent and they've been made applicable to our court. Spousal support cases are going to be a big deal in our court now, but we're here today to talk about child support. We make final decisions in our cases. They're subject to the objection process. The objections are very easy to file. Once our order gets either affirmed or rejected at the judge's level, they go up to the family court judge, then it's the regular appellate process after that. We are a court of law, not of equity, even though we sometimes blur those lines. We can only do what the law allows us to do, Articles 4 and 5 of the Family Court Act. We do follow the rules of evidence. The petitions are our pleadings. We hold pre-trials. If there's 2 attorneys on a case, and I think the rest of us, but I will always call you in first and say, okay, what have we resolved? What haven't we? What can we resolve? So you always have a chance to talk to us before a hearing. We settle a lot of our cases. Our courts would break down if we don't settle cases. So we mediate, arbitrate, whatever you want to call them. We try to resolve the cases. The 3 areas that we have are establishment, modification, and violations. We've talked a lot about that. Establishment, we mentioned that we have to have some paternity establishment in some way. A lot of the cases we get are from by acknowledgement of paternity now, it seems. Modifications, you know, there's 3 different burdens to modify. Jim had mentioned that earlier. The standard change of circumstances, the 15% in the 3 years. Modification can be of our order, of an order of another court in this state, of a court of another state. It's really a 2-part analysis, modifications. Number 1, there's a burden, have you met the burden for modification, be it any of the 3 burdens? And once you meet that burden, then we're starting in a de novo basis for establishing support. The burdens are pretty much mechanical with the 3 years and the 15%. The modifications, it's a snapshot. When we're all doing hearings, sometimes we forget to show, we're so intent on showing what our circumstances now, we need a lower support, we're so dire, we can't pay our bills. What was it before? What was it when the order was established? So make sure you deal with it in that way. What was the order then? What was it now? What's the difference? What should I do now? A picture then and a picture now. Finally, enforcement and violation cases, again, of our orders, of an order of another court. On the violations, they're of our orders. We assign counsel, and we can recommend incarceration. On the enforcements, we do not assign counsel generally because there's not generally the implication of contempt. However, once we take that enforcement, that order from Supreme Court, we establish it our order, we put it through child support. Then when it comes back the next time, it can be a violation. Our sanctions and violations are the money judgments, all kinds of license suspensions. You can find willfulness, refer it to a family court judge who confirms and generally orders what we recommend. You should know that lack of visitation is not a defense. We strive to keep those separate. Settlement does a couple of things. Number 1, it provides certainty. Jim's client knows what his client is getting. Allows you to be creative. You can do some things. I'll take the income tax exemption on a settlement. I do the medical insurance deductible by settlement that you might not get out of me. So you can be a little more creative with settlement. And I think certainly once your client is a part in the settlement, I hope that he or she is going to be more apt to follow the settlement.
That is the best part about settlement, is coming up with some things that the courts just can't order, but we can come up to ourselves. Like if you were to consider somebody's federal last taxing and say they made $100,000, but $30,000 of that was based upon bonus money and isn't there at any particular time. We might be able to take a portion of that and lump it out as a settlement. We might be able to do, as John had said, the tax deductions as part of a settlement. We may be able to do a little bit more maintenance than child support to try and help somebody out at the end of the year. So there are so many different ways in which we can try and make those numbers easier for the person paying it and maybe a little bit more accepting to the person receiving it. When you go to a hearing, it's a thumbs up or a thumbs down, and you are rolling the dice, regardless of how you feel your case is strong on the law. Depending upon what Sue feels that particular day, or what Judge Amon feels, you could be off. And now you've got some explaining to do to your client if in fact you didn't provide them with the reasonable expectations. Anytime you're not going to settle a case, you want to make sure you give them the parameters. I always give, in my opinion, this is the worst thing that's going to happen to you. This is probably the best thing that's going to happen to you. And the truth of the matter is, it might fall in between there somewhere. You know, sometimes the payer will say, he or she is making more than I am, or they're getting half my check. And sometimes I explain that to my clients, well, yeah, you might be living by yourself and your ex and their 3 kids. So you got 4 people on this side of the equation and 1 on that. And when you start to explain things a little bit better, sometimes that pill comes a little bit smaller. But by doing that, in regard to putting settlements together, you can adjust that. There's certain mechanisms that you can reach that are completely out of the realm of the court, meaning like who's gonna drive, who's gonna pick up an extracurricular activity as opposed to child support or some of the add-ons. Some of the things that neither one of the courts can actually order to do. Settlement is always a great way to do it. Now, I'm not trying to sell anybody to sell your client out and push them into a bad deal, because I'm assuming that all of you know the law and all of you are providing your clients with the law in order to reach a settlement that is equitable for everybody. If it's not, don't settle it. And there are cases where I feel as though the Child Support Standards Act should not apply for the reasons that Judge Amon had provided before. The other side, absolutely not, they're not buying it. Well, those cases, you gotta try. And it also makes the process go faster. There's no need to keep coming back. If I come in and say, Judge, my hands are tied, this case is gonna be tried, then we schedule a hearing. You get a day certain, it's done and it's over with, as opposed to coming back, trying to massage it, see what we can do. When you know that's not gonna work, don't waste either one of their times, or yourself. Get it done. And sometimes the date certain, in and of itself, will help you settle a case. When you know that you have a trial that is coming and it's not gonna be adjourned, everybody is going to go, everybody's feet's gonna be held to the fire, a lot of times they settle on that date. So settlement is a great and a necessary portion. Now, we couldn't try every single case that comes in, but it's a way in which both sides can feel as though they got something too. Never think a settlement is a sellout to your client or that you're not gonna try a case. You as attorneys know where this is going to go. You know the background of the case. You know pretty much where this should go. Settlement is a great way of actually having a win-win situation where that wasn't going to happen. They'll ask your clients, have you had an opportunity to talk to your client or to your attorney? And you better have. You don't want your client to hear the settlement for the first time on the record. They're gonna say yes. Are you voluntarily going into this? Yes. Has any other promises been made other than that? No. And make sure you run that through. You walk in there on a settlement, everybody knows the terms and conditions. Every once in a while there's a blip or something like that. And if anybody here is putting it on the record, always say, subject to my colleagues' additions, modifications, or clarifications. So that way it always gives your colleague the opportunity, if you forgot something, or something needs to be a little bit more clarified for them. It should never be a term that is completely never discussed. Settlement only happens though when you do your work. If you don't do your work and you settle it, that's a case where you could be selling somebody out because you don't know. Do your work, understand your case, settle it if you can.
By the way, when you're settling the case, I know you're busy and the hallway discussions, but make sure you talk every issue out. I'll get attorneys in case it's settled, they put it on. All right, when is the support gonna start? Of course, Christina, well, I want it back to the date of the filing. Well, the case isn't settled. I mean, that was a significant issue. Or we'll get the settlement all done, and then someone will say, well, by the way, I want attorney's fees. Well, that was a part of the discussion, and maybe we can do that quantum merit afterwards. But make sure you try to think all those things in. Checklists, before you go in on it, the night before, so checklist what issues got to be addressed and make sure you address them before you come in.
And remind your client that if they're the ones filing, data filing. So that's a very good point Judge brings up, that if in fact by the time it gets to trial, it's 3 or 4 months, that's 3 or 4 months worth of back pay that is now, or arrears, that is subject to settlement. The court has to take the data filing. So
At a
it's
hearing.
all the way back. If you make that part of your settlement, you could use it any date. The date of your settlement, halfway through, whatever date you guys choose, you can and place it on the record. But know that your client, if your client is the payor, that they go back to the date of filing. And if you're receiving, they have to know that they had the option, if it was going to a hearing, that the court is going to go back to the date of filing. So those are important parts of that, because if it is the hearing date that you're getting to, that is a lot of money that can be accumulated.
Do not settle for how much you're gonna pay on arrears if you're using the support collection unit. What you will find is, here you are, I'll pay you $100 a week and I'll pay you $50 towards arrears. It goes to the support collection unit. They're taking their administrative amount. They'll collect the 100 basic, they'll collect the 50 towards the arrears that you volunteered, and they'll collect another 50, which is their administrative amount of half the base amount. Do not put any arrears in. Let the unit take care of it if you're using the unit.
I'll spend a couple minutes talking about the support collection unit now before we get into the hearings, and I'll address that issue. A lot of what we do involves how the support is paid and what's going to happen. The things that Eileen said, those are very important issues. 3 ways support can get paid. It can be paid direct between the parties. The parties get along, they want to stay out of the system, they want to take care of the record keeping themselves, that's fine. It can be done by what's called an income withholding order. That would cause the support to go directly from the employer to the custodial parent. It would, I think, anticipate that someone's been at a steady job and is going to be there, because the downside of an IWO is that if employment changes, it just stops. You have to file a new one, or ask us to file a new one. The third way then is the support collection unit. So direct, IWO, or support collection unit. I would say 9 out of 10 of our cases go to support collection unit. Why would you go through the child support collection unit? And by the way, the custodial parent ultimately has the right to choose by regulation. Why would you use the support collection unit? Well, the powers are extensive. First of all, they're going to collect the money by IWO, and it's an IWO that's going to follow from employer to employer. You don't have to do anything else. Somebody changes a job, there's a new hire registry, the employers have to report to that new hire registry. The child support computer system links up with that, a new IWO goes out, and at some point it starts up again. So they do the IWOs, they keep the records. The support collection unit has a lot of other enforcement remedies. They have the administrative add half of the support obligation. So if the support obligation is $75 a week, if there's arrears, $37.50 will come out as the add-on. Support collection unit will intercept income tax returns if there are arrears. That's a high priority. Lottery winnings, contact the Department of Taxation and Finance. Properties are taken, bank accounts are frozen. I see a lot more of that recently. So there's a lot that the child support unit can do and will do.
If I could just add something on that where somebody wants to stay out of the system, the person who wants to go through the collection unit, and that's the one thing that is blowing up a settlement, what has been suggested and used is, okay, if he misses one payment, we utilize the support collection unit. If he's good, then he's out of the system. And it keeps both of them getting what they want.
One thing I wanted to add too is if you use the child support services, you have to use all of them. You can't say, okay, we're going to do current care child support, but the arrears we're going to deal with on our own. Because once child support finds out there are arrears, they're going to either say, look, we're taking them and we're going to collect them, or you don't have our services.
Everybody outside this room, all our clients know it is trials. So say trial, hearings, the same thing. I'll interchange them all the time. You got to treat these just as though as any other trial. You got to do your discovery. You got to interview your witnesses and make sure you talk to them. Nobody should hear questions for the first time when they're on the stand. Any witnesses should be talked to beforehand. I really, and I know all our support magistrates, and I know everybody at Expedite hates to have children involved in hearings and testify between mom and dad. Any way that that could be done to be able to avoid that, you should. They are 99.9% of the time the innocent pawns in all this, and they should not be forced to testify under normal situation against mom or dad. It's uncomfortable for everybody. If you can avoid it, I suggest that you do it. Anything else? Any other witnesses? They should be called, they should be talked to. If they're not, and they're an integral part of your case, subpoena them. If there's documents that require the support magistrate's signature, get that done. You have to know that, because if you find that out and you need documents and you start that process 10 days out, you're gonna blow it. You're not gonna get it. And when you have a date certain and both of their calendars are jam-packed, you're not gonna be able to just adjourn it for a day or two, or sorry, my subpoena stuff didn't come. Be ahead of the game. Start doing that early, getting that out there, because if you run into trouble, you get time to fix it. And if you don't have time to fix it and it was a germane part of your case, it's not the court that you have to blame. Have your client in, go through, mock cross-examine them, go through everything that you think might be asked of them. I always tell my client, I can't ask you everything that's going to be asked of you, but I can kind of narrow it down to some of the important issues that I think are going to be there. See how they answer the case. I always tell my clients, when they're testifying, short as possible, and tell the truth. Don't volunteer any information. Most people, when there's a silence, have a tendency, they want to talk. They want to break the silence. They want to say something. You got to tell them to fight that urge. Have copies of your documents ready to go, because you're going to get them marked, and you have to give copies of whatever you're getting marked to your other colleague. If you're going to be introducing them to evidence, make sure you know how to do it. Don't just hand a document to the judge. Know your rules of evidence. If there's any hint that I could give to anybody in regard to trial, the best thing is knowing the rules of evidence. That is crucial. If you know the rules of evidence and you know your underlying law, you will have a leg up on everything that you're doing. I know I keep going back to this, but the unrealistic expectations blows so many things up. And even if you're not successful, your client will understand probably why. Because you have pointed out the strengths of their case, the weaknesses of their case, what we need to prove, what they need to prove. And they know when they're sitting there 9 times out of 10, they know how the case is going. They know how they testified. They know what's going on. I treat a support case no different than I treat a Supreme Court case. I get everything together. I set aside an afternoon for testimony, witnesses, documents, get everything all set and ready to go. And win or lose, your case will look better. You'll feel good about it. And God forbid the support magistrate gets it wrong, you've got everything ready to go for your objection. It's already built in because you already have copies of everything.
We're not happy adjourning cases at the last minute. Now, we don't want to jam you up, certainly, and things happen. But especially tell us the matter's got to be heard, and we set it for hearing, and we know there's going to be testimony, and we set aside a part of our afternoon for it, or part of our morning. We expect that to go. And you come in and you say, well, I didn't get the materials. To come in the day before, or to come in that morning and say, I didn't get the financial affidavit. I mean, there's no excuse for that. If you have any issue with discovery, you let us know ahead of time. Copy the other side, we'll set up a brief conference. I want to know about those things ahead of time. When it's set for hearing and you come in, I expect you've got all the documents that you're supposed to have. And if you don't have something, your subpoenaed records come in, be prepared, because I might say, all right, we'll do something on that, but let's start the case. We'll go around issues that we can hear right now. So you got to be ready to go, but you got to be prepared. He said it. What witnesses? What order are you going to call them? Are you going to call the other side first or not? Are you treated a hostile witness? Those kinds of things. How we're going to address those kinds of evidentiary things. The questioning, as Jimmy said, we have iPads and computers, but the yellow pad method, you outline. Sometimes you have to do every single question. That's the way it's best for you, and that's the way you're learning to do it fine. Or just areas, and you check off when you get them done. What kind of documentary evidence are you going to present? Are you going to have a problem getting it in? If you got a report from a doctor that your client can't work, anticipate what's going to happen with that. That we're going to keep it out. You want to get it certified. You want to get the other side to agree to it first. What is the law? What is your legal burden? That's part of the whole flow of the case that Jim's been talking about all along. Preparation of your client, outline the direct, and practice the cross, just as Jimmy said. That's very, very important. Subpoenas. We talked about subpoenas, but I think there's no reason why you'd subpoena the wage records of the non-custodial parent unless you've gotten sufficient information to start with. But don't depend on the fact that they're gonna come in with their tax returns or their pay stubs and all that. They should, but be ready. Anticipate what's gonna happen and not happen. Think it through the night before, the day before, the week before. How do you expect this to go? And try to anticipate problem areas and be ready for them. That's the easiest way to do it. And it certainly is the most effective way to achieve the result. I wanted to mention very briefly the Uniform Interstate Family Support Act, UIFSA, which is found in Section 580 of the Family Court Act. UIFSA was passed in 1997. It's a very technical procedural statute that deals with support when parties reside in different states or different countries. And state is interpreted very liberally. It's country, territory, tribe, etc. And the UIFSA was mandated by the federal government. UIFSA is the same in every state. Every state has UIFSA, and it reads the same. To get an understanding of why we have it, prior to UIFSA, each state had a statute that would deal with these kinds of issues, but they dealt with them differently. So you might get an order in New York, and then the parties might move somewhere else, or one party moves somewhere else. In Pennsylvania, get an order there, and there might be 2 or 3 orders. Each state thinking their order is the controlling order, the one and they would take that position and follow that. So you wind up with 2, 3 orders on a case, and it was very messy for the parties, for the children, for the courts. It was untenable. So the federal government passed UIFSA, and we basically now have a one order system with UIFSA. Although there's still some old ones around. But some basics on UIFSA. There has to be jurisdiction, number one, for an order of support. So if you want an order, if it's an initial order of support, and your client lives here, and the respondent lives in California, there has to be some nexus to the respondent. You're going to want your case heard in New York, because New York's one of the 4 or 5 states that has emancipation at 21 yet. So you're always going to try to bring in the long arm into New York. But if this child is conceived out of the state, and the only nexus is that your client lives here with the child, and where the child lives is not a significant factor. He's been in California, you're not going to get it here. So you got to know the bases of jurisdiction and follow that. Once an order is established, that's the order for the case now under UIFSA. That order continues to be enforced or modified in the proper jurisdiction. Once an order is established in our state, if any one of the parties continues to reside in our state, we have continuing exclusive jurisdiction. Even if mom and the child moves to California and lives there for 10 years, if dad's still here, our order, we have the continuing jurisdiction to modify. If neither party resides in the state that issued the order, the person seeking relief has to file in the other person's state. By file, I mean get a registered copy of the order for the divorce, register it there for modification or enforcement, and then it will be heard there. The law of the state that initiated the order controls throughout the duration. So if New York enters an order, it's 21, and parties move elsewhere and get it modified elsewhere, it remains 21. And if there are multiple orders now, there is a methodology for resolving those issues, but we have to get into the statute a little bit. UIFSA is a tough area of the law, because, and for several reasons. Number one, it's purely procedural. Number two, you're not going to get a lot of cases, so you're not going to remember what happens. So what you have to do is take a look at the law when you get a case like that, or ask us. Of all the questions I get, probably a lot of them, the bulk of them are UIFSA type cases.
I've always thought one of the main features of UIFSA is that you use a public official who goes to a counterpart public official in the other state.
If it is going to be a 2-state proceeding like that, yes. And Bob Figliola is presently the UIFSA attorney, and I think you should take, and it's a good point, you should take advantage of his expertise. Jimmy, anything you wanted to add?
You know, there's just some of the common things that I get asked all the time is, my child's working full time, do I still have to pay support? My rights were terminated, do I still have to pay support? My wife got remarried and the husband makes more than I do I still have to pay support? So the general answer to probably all those are going to be yes. It's going to be the exception that you don't have to pay support, and it is your burden to find that exception and plead and prove that exception and get an order. The other thing is, we agreed that I wouldn't pay support, and now a year later, a violation petition has been filed. And there's no superseding order that says that it's been suspended, terminated, or otherwise. Don't do it.
Child support agreements have to be in writing, sanctioned by the court.
Correct. So always look for something to be quantified. Use the courts when you have to. General promises, always going to be paid support. Look for the exception. They're out there. Got to find them. And the courts will always hear them.
Thank you all. Good
Thank
luck.
you.